Good evening, everybody. Welcome to our Constitution Day event. My name is Charlie Whelan. I'm a senior lecturer in the Rockefeller Center. We are lucky to have Judge Lawrence Silberman with us today, both to celebrate Constitution Day, but also because the judiciary has been in the public consciousness more than at any point in recent memory. Before I introduce Judge Silberman, a couple housekeeping items. If you are doing the live stream, you can email your questions to rockyqa@dartmouth.edu. Those in the audience who would like to ask questions, there should be note cards that have been distributed. You can pass them to the aisle near the end of the judge's talk, and then I will go through them and try and get to as many of them as possible, perhaps synthesizing some of them along the way. Judge Lawrence Silberman, 57, was appointed United States Circuit Judge in October of 1985. He took senior status on November 1st, 2000. He received the Presidential Medal of Freedom on June 19th, 2008. He graduated from Dartmouth College in 1957, Harvard Law School in 1961. He served in the Army. He's been a partner in law firms as well as a banker in San Francisco. He's also had a long and distinguished career in public service. He served as an attorney in the National Labor Relations Board's appellate section, solicitor of the Department of Labor from 1969 to 1970, Undersecretary of Labor from 1970 to 73, Deputy Attorney General of the United States from 74 to 75, and Ambassador to Yugoslavia from 1975 to 77. From 1981 to 1985, he served as a member of the General Advisory Committee on Arms Control and Disarmament and the Department of Defense Policy Board. He was appointed by the Chief Justice to a term, 1996 to 2003, as a member of the Foreign Intelligence Surveillance Court's Review Panel. He took a leave of absence from the bench to serve as co-chairman of the President's Intelligence Commission. He was an adjunct professor of administrative law at Georgetown. He's also taught at Harvard, Georgetown, and as a distinguished visitor from the judiciary was awarded the Charles Fahey Distinguished Adjunct Professor Award for the 2002-2003 academic year. I was lucky enough to have lunch with the judge, so I know all the scintillating topics that are on offer. As I said at the outset, this is a really interesting time, and there's no one I can imagine who's had more breadth and a better view to discuss some of these topics. So I turn it over to Judge Lawrence Silberman. Thank you very much for joining us.
Thank you very much. I'm here independently for my 65th reunion, and a number of my classmates are here to try to protect me in case anybody attacks me.
I'm here as well.
This is a Constitution Day talk. I will address one of the most contentious constitutional subjects today, the First Amendment's protection of free speech. As I noted in a recent opinion, the First Amendment's guarantee of free speech is not just a legal doctrine. It represents the most fundamental value in American democracy, a national commitment to uninhibited political speech is a crucial aspect of the country's culture. It is the penumbra around the First Amendment, which by itself only prohibits government control of speech. Unless all American institutions are committed to free political speech, I fear the strain on the First Amendment's guarantees will become unbearable. Those seeking to suppress free speech sometimes think that provocative, even extreme and obnoxious political speech is dangerously divisive, and it should be suppressed. I think that is profoundly wrong. I think it's the very opposite. Toleration of all versions of political speech, whether you agree or disagree with that speech, is the crucial unifying factor in our country. Some years ago, I was ambassador to Yugoslavia, a communist country where freedom of political speech did not exist. I had a small fund with which I could send promising young intellectuals to the United States for the summer. Yugoslavia was then a country of 6 separate ethnicities, and was threatened by centrifugal forces. Those forces eventually set Yugoslavia apart into 6 countries. But in any event, at those times, the government sought to squelch talk that threatened Yugoslav unity. One intellectual I sent to the United States came back. He expressed wonderment that our country, composed as it is of the descendants of an enormous number of nationalities, could nevertheless enjoy such a uniform commitment to shared values. I explained, we all swore allegiance not to a sovereign, not to a blood grouping, but rather to a legal document, the Constitution. And nothing in that legal document was more important than the First Amendment. Protection of the speech of fellow Americans, even the most provocative and unpleasant, reflects a fundamental tolerance for all Americans. I was often obliged to explain the First Amendment to the Yugoslavs who demanded that I restrain the New York Times criticism of their government. Their eyes would glaze over when I explained the First Amendment. They had enough of the lectures. But then I pointed out that if our government could influence the New York Times, a Republican administration would have every incentive to do so. That finally worked. It got across. But interestingly, even allied Democratic governments that generally supported free speech were mystified by the strength of our First Amendment. To be sure, I recently wrote an opinion seeking the overturning of New York Times v. Sullivan, a case that benefits the press. That case, by constitutionalized American libel law, made it nearly impossible to sue media for certain inaccurate personal attacks on public figures. Some have suggested my position reflects less than a vigorous support for the First Amendment. On the contrary, I opposed New York Times v. Sullivan because, in my view, it was wholly illegitimate policymaking by the Supreme Court. A guarantee of free press does not mean special immunization from accountability when the press libels a person. A free press is not necessarily an all-powerful press. The Supreme Court in Sullivan was legitimately concerned about problems created by excessive libel actions against newspapers supporting the struggle for civil rights. But that could have been handled, as certain scholars have pointed out, by legislation. It was illegitimate for the Supreme Court to literally make up constitutional law to deal with the problem. Its decision was contrary to text and history, and it created new problems for society in the form of the media that can spread false rumors and sling unfounded accusations directed at public figures without consequence. Now let me go back to the history of the First Amendment. It's fascinating. The phrase freedom of speech first appears in the Anglo-American tradition in the Bill of Rights written in 1689. It only protected the expression of members of Parliament. This was so because in the English tradition, Parliament, not the general population, was the source of sovereignty. Our founders extended that right to all citizens because here the people were sovereign. As many of you know, the First Amendment was drafted by one of the most extraordinary of our original political leaders, James Madison. His primary focus was freedom of the press, which was included in the Constitution of virtually all the colonies. The phrase freedom of speech only existed in one of those. But if one thinks about it, which clearly Madison did, freedom of speech was a necessary corollary of freedom of the press. It followed apodictically. If you protect words that appear in the press, you couldn't suppress those words uttered verbally. There are virtually no cases in the first half of the 19th century involving the First Amendment's freedom of speech. As I'm sure some of you know, the First Amendment did not apply to the states until after the Civil War, when the 14th Amendment Due Process Clause was seen to incorporate, amongst other things, the First Amendment. The first case I could find considering the First Amendment's free speech clause as applied to the states was Patterson versus Colorado in 1907. It included a magnificent dissent by one of our greatest justices, John Marshall Harlan. He was the man, many of you will remember, who dissented in Plessy versus Ferguson from the odious view that racial segregation, although separate, could nevertheless be equal. Patterson involved a state judge who held a litigant in contempt for criticizing the judge's opinion. Sometimes I'm sympathetic to the judge. The majority upheld the contempt finding. Harlan disagreed. He said, "I cannot assent to the view if it be meant that the legislature may impair or abridge the rights of a free press and free speech whenever it thinks the public welfare requires that to be done. The public welfare cannot override constitutional privileges." He concluded that the privileges of free speech and a free press belonging to every citizen of the United States constitute essential parts of every man's liberty. Not surprisingly, the constitutional protection of free speech from government action has been most strained when we face national security threats. First, there were notorious Alien and Sedition Acts growing out of the three-cornered fighting between the United States, Great Britain, and France. But those statutes were abandoned before the Supreme Court had an opportunity to rule on them. Perhaps most astonishing for those of you who are historians is the degree of Lincoln's tolerance of free speech, even during the bloody Civil War. He did, to be sure, strain the First Amendment on occasion, but given the threat to the nation, it's absolutely amazing how tolerant he was of press criticism or speech. For instance, he announced that the arrest of Vallandigham, a Southern sympathizer, was wrong if that arrest was based purely on Vallandigham's criticism of Lincoln. And instructions to his general, who had done the arrest, in dealing with Northern civilians ailing Confederate guerrillas, Lincoln explicitly directed General Ewing to only arrest individuals or suppress assemblies or newspapers if they are working palpable injury to the military, and not in no other case will you interfere the expression of opinion in any form, particularly criticism of the president. Then we have the 20th century's wartime pressures on the First Amendment. Some of the most celebrated First Amendment opinions, Abrams, Gitlow, Whitney, were the result of challenges to laws passed to suppress wartime protests. Perhaps the most problematic was the McCarthy era, which my class of 1957 experienced at the time we entered Dartmouth. The notorious senator from Wisconsin was able to intimidate politicians, academics, and Hollywood writers in his wide-ranging and, in many cases, wholly unjustified pursuit of alleged communist sympathizers. Turning to the present, I am unfortunately convinced we're faced today with a worse threat to free speech than during that earlier time. Some political speech is attacked as if it were blasphemy drawn from the colonial period when witches were being burned at the stakes. Threats against political speakers are not simply levied by unscrupulous politicians. They come dishearteningly, heartbreakingly, from young people influenced by academics. Ironic Ironically, it was those academics who were the prime targets of the McCarthy era. Certain controversial subjects are placed out of bounds. I am shocked at the recent challenges to free speech in our precious academic institutions, particularly the Ivy League. For example, recently at Yale Law School, students attempted to stop, then drown out, a public dialogue between a conservative and liberal lawyer. The thing that's so extraordinary is they were both supporting untrammeled political speech. The administration's response was to vaguely gesture to the importance of free speech, but also to celebrate respect and inclusion, whatever that means. The dean sent a letter calling the behavior unacceptable, but she did not so much as issue a slap on the wrist to the students who maintain their hostility to free speech. Then at Princeton, Professor Joshua Katz was stripped of his tenure and fired after challenging the university's orthodox views on race. He was terminated ostensibly based on the disputed details of a consensual relationship he had had with a student 15 years ago, for which he had already been punished. This was only after he criticized a Princeton faculty letter that demanded preferential treatment for minority faculty and black student organizations. Does anyone believe that Katz would have been fired if instead he gave a speech in support of a black student organization? Similarly, at Harvard, Professor Roland Fryer, one of the most gifted economists in the country, who happens to be black, has been suspended for 2 years for allegations that he made inappropriate comments. His supposed crime was telling raunchy jokes. Can you imagine a professor telling raunchy jokes? I couldn't get over it. But Fryer's real crime was his work empirically demonstrating that police do not kill blacks at a higher rate than other races, and that black students excel when faced with high expectations, challenges to current shibboleths on race. Then we have Amy Wax, professor at Penn Law School. She was recently punished, and it looks like she's going to be expelled, because she unwisely, indeed somewhat cruelly, described her experience over many years regarding black student performance in her class. She therefore touched on the mismatch theory, popularized by Richard Sander and Stuart Taylor. They wrote a book by that name, and they filed a brief in the Supreme Court, amicus brief. They contend that in an effort to achieve soft quotas, elite schools artificially admit less qualified minorities, thereby injuring the very students supposedly benefited. And in other words, in a less competitive school, the students might do much better. I emphasize that as a judge, I take no position on the mismatch theory, although some have predicted you will see reference to it in the forthcoming Supreme Court opinion dealing with the Harvard case. To be sure, it is unseemly for any serving professor to suggest that minority students are less qualified, although that position is expressed openly by emeritus professors no longer teaching, like Alan Dershowitz at Harvard Law School and Stanley Goldfarb at Penn Medical School. Then going back to Andy Wax, in furtherance of her tendency to offend minority groups, she recently attacked Asian Americans in the most unflattering terms. I gagged when I read her remarks. For free speech is free speech. Even Dartmouth, to my distress, engaged in smothering provocative speech. In January, the college canceled an event with Andy Ngo, a controversial conservative journalist, maybe right-wing journalist. His speech was forced online based on unspecified information from the Hanover Police Department. Dartmouth has apparently been evasive about the credible threats it received. It provides shifting rationales for its decisions. And the college Republicans who supported no have also been charged $3,600 for an event which did not take place. Thinking about it, I think it's inappropriate for the college to ever charge organizations for the protection their speech requires. That policy simply encourages those who want to cause as much trouble as possible. It simply accentuates the powers of those who would discourage free speech. If the Dartmouth administration or any other Ivy League school had the backbone to discipline students who shouted down speakers or to arrest non-students for disrupting events, the deterrent effect would obviate the need for imposing security expenses. Regardless of the situation, the college aligned itself with those who wish to silence speech by canceling the event. It should be recalled, for those of you familiar with Supreme Court cases, that in Terminello, the Supreme Court squarely rejected the so-called heckler's veto rationale for suppressing speech. The court held that speech cannot be punished, merely could cause unrest amongst potential listeners. A common thread of these incidents at Yale, Princeton, Harvard, UPenn, and Dartmouth is that universities' authorities in discouraging unfashionable speech do not do so explicitly. Rather, they perform what I've called an Ivy League two-step. First, they pay open lip service towards the value of free speech. Then they use alternative reasons as a pretext to shut down objectionable speech. That in some ways was more dangerous than a frontal attack. Even assuming there are some circumstances in which speech can legitimately be restrained, and there are some, we have seen that schools have been inclined to dissemble in their justifications for suppressing. It is for that reason, in my view, when universities take action to limit free speech, they have solemn responsibility to be absolutely honest and transparent in why they are doing so. They must, as Oliver Wendell Holmes said, turn square corners when demanding such accommodations. So far, our Ivy League schools have demonstrated a pattern of suppression that should upset all friends of freedom of speech. I hope and expect that Dartmouth's new president, Baylock, will have the steel in her spine that is needed to take this responsibility seriously and stand up for free speech when it becomes difficult. Her recent statements have been encouraging. But when the chips are down, many university presidents have folded. Admittedly, one of the most serious questions the country faces is how to achieve racial equality. Does it mean equal opportunity or equal results? Is progress for African Americans and others, for instance, held back because of residual racism or because of other aspects of the Black experience? Views about achieving racial equality that are uttered in good faith are repressed, even shut down as racist, if they vary from certain orthodoxies. As a result, the charge of racism, not unlike McCarthy's frequent cry of communism, has been drained of much of its meaning. Similarly, debates over issues relating to sex, education, sexual identity, issues about which many hold sharply divergent views, sometimes based on religious differences, are ruled unacceptable. These repressive forces come from the left side of our political spectrum, but I can think of examples coming from the opposite political pole. Although it is certainly reasonable for parents to argue about the curriculum of public schools, it is intolerant to seek to ban library books on critical race theory, at least at the high school level, let alone at the college level. By the same tokens, efforts to prevent persons such as Linda Saussure from speaking on college campuses in support of BDS, boycott, divestment, and sanctions directed against Israel, are equally intolerant. As a one-time special envoy in the Middle East, I regard BDS and Sassoure's views as particularly obnoxious, but I deplore the effort of Jewish groups to prevent her from speaking at universities. My class at Dartmouth, as I mentioned, entered in the fall of '53. The previous spring, Dwight Eisenhower spoke at commencement. He implicitly attacked Joe McCarthy and McCarthyism, admonishing students, don't join the book burners. It was a spontaneous speech. It wasn't written. Consider the context of his speech. We were in the midst of a Cold War with the Soviet Union. We had lost over 50,000 American men in Korea. And indeed, there were some pro-communist traitors in our government, as well as allied governments. Nevertheless, Eisenhower courageously said, how do we defeat communism unless we know what it is and what it teaches and why it has such an appeal to men? Why are so many people swearing allegiance to it? And we've got to fight it with something better, not try to conceal the thinking of our own people. And this is the part I love. They are part of America. And even if they think ideas that are contrary to ours, the right to say them, the right to record them, the right to have them at places where they're accessible to others is unquestioned, or it isn't America. Because McCarthy was a Republican, it was important that Republicans, most notably Margaret Chase Smith, the Doughty senator from Maine, and then Eisenhower himself were the ones to speak out and put an end to his reign of intolerance. I hope Dartmouth students on both sides of the political spectrum will stand up for freedom of expression. It's not as partisan issue. As I've tried to explain, fundamental to American democracy. To be sure, you may have to draw upon the granite of New Hampshire in your muscles and your brains to withstand the immense pressure to bow to conformity, but I expect nothing less. Thank you very much.
If you have questions, I think we will solicit. And again, if you're on the live stream, you can email your questions to rockyqa@dartmouth.edu. I will exercise my prerogative to ask the first couple questions. Eisenhower was here in, what, 1957?
53.
53, of course. And he might have anticipated that we have drones and other kinds of things, but he probably never imagined social media. So can you walk us through the legal landscape of navigating the First Amendment in an era when there are tools that can be used and algorithms and other things that can amplify and smother speech in a way that we'd never really thought about before?
That's a tough question for me because I, as one of my law clerks sitting here knows, I am dreadfully ignorant about social media. But I do note that students who come to me as law clerks from good law schools and occasional Dartmouth graduates will tell me they're afraid to speak their mind even amongst friends for fear that something they say will end up on social media. I am terrified about that and troubled about that because it extends to a level of repression that I wouldn't have visualized and Eisenhower wouldn't have visualized. So you're right, I don't have an answer to that yet. I won't live long enough to come up with an answer to it, but it is a very troubling problem.
Let me put a
and that's repression of speech that comes from your own community.
Let me put a finer legal point on it. How do you feel about Donald Trump being banned from Twitter? So you have a private company, certainly some noxious speech. On the other hand, it really diminishes his ability to reach people, albeit via a private company.
Let me think about how I can answer that without
Briefs, you need briefs.
stepping over the line. As some might note, I'm hardly an admirer of the former president, but I think it's troubling for any company that has market power in the media, or roughly market power, to be repressing speech based on political judgment, even if I agree with their views and not the political judgment. I am troubled by that. But they are private companies, of course, and they have a legal right. Some of the private companies have such political power that it is argued they can be challenged as on a regulatory basis, like railroads. I don't think so far anybody has come up with a good theory on that, although Justice Thomas wrote an opinion in which he suggested that there is, however, another aspect of it which presents a serious legal problem. If the government leans on a major social media company to take a position politically, that may raise a First Amendment problem. That may be the government stepping out of line and could be challenged by an injunction. And there are allegations of such. I haven't seen a case yet.
So the cards somehow need to get up to me at some point.
Those are tough questions.
Well, I'm not done yet. So let's bring it closer to home, which is Dartmouth prides, like most academic institutions, prides itself on freedom of expression, your critiques notwithstanding. There's also a principle of community, which is to say we're a community of people, we're meant to support each other, not to create extreme discomfort. Are those principles in opposition to one another, and if so, how ought we reconcile them?
I don't think community can ever trump diverse political views. That's just another way. I mean, that's what I remember in Yugoslavia. That's just another way of repressing political speech.
All right, so now we've got questions here with mediocre handwriting. Another concurrent threat to free expression has been the pandemic vaccines and public health dialogue. What are the legal and ethical implications of the private attempts and even the public interest in suppressing dissent in a public health situation like this?
Suppressing dissent?
Well, people, the vaccine deniers and so on. Is there any public role in suppressing?
Some of the arguments are not crystal clear. Some of the issues on vaccine were issues on which the government varied. I think the government had every right to push their views as to what was healthy for the country and be critical of those who were critical of the government. But I don't think you can repress. That was a political issue. I don't think you can repress political speech.
So this is a question about the incidents that you brought up, Yale, Princeton, et cetera. Is protesting speech also, or not also, political speech? So where do we draw the line between those who are protesting the speakers? Can you drown them out?
If you think about that, that turns in a circle. If you think of the protest shutting down a speaker as free speech, then you've created a reductio ad absurdum. That's ridiculous, I think. Just ridiculous.
And
it's like, screaming, that's like arguing that screaming fire in a crowded theater is free speech.
So I want to follow up on your examples. Are there any counterexamples of institutions in higher education or elsewhere that have taken a particularly bold stand?
Chicago.
And is there a specific incident? I know there's the Chicago Code, but are there speakers?
Yes, there was a speaker, there was a professor at Chicago who took a controversial position on one of the race questions on admissions, and he was asked to speak at MIT on a scientific subject. MIT canceled the speech based on protest. Chicago made clear they were endorsing him. University of Chicago has been the best of our elite institutions in protecting free speech.
So some questions about the Supreme Court. I think we'll look forward and we'll look back. Let's start by looking forward. Do you have thoughts on the upcoming case involving the merits, legal merits of affirmative action? You alluded to that in your remarks.
I think, this is a prediction, I think it is likely the Supreme Court will overrule the First Circuit in the Harvard case. And more likely than not, well, of course, the fact they took the case is a pretty good indication of that. More likely than not, overrule Grutter, which is the case that goes back 25, almost 25 years, that O'Connor wrote, and she said she would endorse affirmative action for 25 years. So I think that was based on a court's holistic view. I think the Supreme Court is likely to take the position John Roberts took in a dissent and an opinion a few years ago. Discrimination by, we have to stop discriminating in accordance with race by stopping discriminating in accordance with race. So I think the court is going to throw it all out.
Now we'll look back, the recent Roe decision. Were you surprised by the decision? And what's your assessment of it? If you were in front of the Senate, of course, you wouldn't answer that question, but you're not in front of the Senate, so we get to ask it.
I wasn't surprised. A number of justices had argued for years that Roe was illegitimate, Supreme Court constitutionalizing. And it was only a question when they got enough to join them who agreed that that would happen. So I was not surprised. It's interesting that the discussion that I've heard somewhat is that it was political. The amusing things about it is twofold. The first is when you go back to the original Roe v. Wade, by political, I'm assuming people mean pro-Republican. If you go back and read the original Roe v. Wade case, it was written by a Republican, Blackmun, and the leading dissent, and I thought a devastating dissent, was written by Byron Whizzer White, a Democrat. So philosophically, people have changed in their view. Probably, I'm not a politician, but probably the Republicans are going to get hurt by the opinion rather than helped, which is, I think, why Justice Roberts wanted to affirm just the Mississippi statute.
There are two questions about...
Which means he was being political. I don't think any of the others were.
There are two questions about hate speech. I'll consolidate them here. What some have the privilege of viewing as casual political discourse, others may perceive as an affront to their identity. What do you see as being the line between political and hate speech? And isn't it within students' rights to speech or assembly to protest if a speaker or individual contradicts the values they expect their school to uphold?
I think that's the slippery slope. Any political speech you dislike can be described as hate speech. Many years ago, the ACLU, I guess it was in the 60s, defended a Nazi group, the most extreme you could imagine, marching in Skokie, Illinois. And I think they were right. I'm not in favor of Nazis, but they were right to protect. Now, I don't think many colleges would ask a Nazi to come and speak. But the problem with the hate speech notion is it's a slippery slope. And any political speech can be thought of as hate speech if you don't like it. If it affects you. And I give the censure example in the Jewish groups who are protesting her speech, her anti-Israel speeches, claim she's engaged in hate speech. But it's a legitimate political issue, even though I may disagree with her. She's entitled to speak if she's invited.
So I have a follow-up. Hate crimes, of course, are crimes that people commit based on hate, but if the hate is constitutionally protected, why is that? Why not just prosecute the crime?
So that's a very interesting question. The key, of course, is you have to have the crime. Without the crime, you can't charge some people with hate. And so that adds to the degree of severity, which the courts have always done. When somebody committed a crime with a particularly obnoxious motivation, it always affected the sentencing. So I don't think this is any deviation.
I want to ask you about a broad class of situations where people have refused to do things because of their often religious beliefs, but it could be other personal beliefs. So I'm thinking of the Supreme Court case around making the wedding cake for a gay couple, but also people refusing in the medical profession to be involved with abortions or even to distribute the abortion pill in the case of pharmacies. How do we mediate public-facing commerce that may contradict people's strongly held and protected religious beliefs?
It's tough. And the Supreme Court has been struggling with several of the Baker cases, and they have another one coming up. They had the football coach praying. I think the court is moving gradually towards a more tolerance of religious expression. Some may argue that, and some have argued, that it brings it back much closer to what the Supreme Court was at before 1946. In 1946, the Supreme Court in the Iverson case seemed to strike out on a path which some scholars, and I think they have some merit, have believed was anti-Catholic. And it wasn't so much a legitimate interpretation of the Establishment Clause. I think the court is gradually moving back on that. On the free exercise, the cases aren't really so dramatic. If the case from last term involved the coach who prayed in the middle of the football field after the game. The school banned him from doing that. I forget whether they fired him or not. And the Supreme Court said that was free exercise. There's really very little at stake if you think about it. If he had called the players to come with him, some of them came voluntarily, but if he had called the players to come with him, that would have been an establishment case. So it's not as dramatic a change.
Do you believe that public confidence in the federal courts has fallen in recent years? And if so, what can the courts and Americans do to help restore that trust?
I don't know whether confidence in the federal courts has diminished. The truth of the matter is, in my view, most Americans are not familiar with how limited a role federal courts have in our society, in our Constitution. And they are often inclined to think that if something is wrong, the Supreme Court should right it. If you go back and read what Jefferson, Madison, and Hamilton thought when they were framing the Constitution, Jefferson worried a little bit about it. Madison and Hamilton said, no, don't worry, that's the least dangerous branch. It's not going to stray from the constitutional boundaries. Maybe Jefferson was right to be more afraid. But I think that the bottom line is the press, to a certain extent, the academics, describe issues as, gee, this ought to be dissolved. This is wrong, and therefore it should be unconstitutional. But that's just what Jefferson was afraid of. He was afraid of an all-powerful judiciary.
The Constitution has limits on free speech that incites violence. So there's a general question here, and then again, I'm going to put a finer point on it. So how should cases mediate that line between speech that gets people riled up and speech that actually incites them to violence?
The Supreme Court has been very limited in that. You have to really be, I forget which case it is. Vincent, which case is it?
The Fighting Words case?
Yeah.
It's like Cesar de the Sea, Chaplinsky, I think.
Yes, I think it is. Anyway, you have to really, really go pretty far over the line in challenging somebody or threatening violence in order to be eliminated, to avoid your First Amendment protection.
Now, on January 6th, were there any presidents of the United States who might have crossed that line?
I am recused on that issue, but I shouldn't. I'm recused because my cousin is a Democratic congresswoman from Virginia and sitting on the January 6th committee. And a law
You
clerk
got lucky on that one.
a law clerk of mine is on the other side. So I was deputy counsel to Trump. So I'm recused. And I really would rather not express a view on it
That
if
I
I
know,
wasn't
but-
recused.
One of the things we talked about at lunch, and you just alluded to, is if people want social change, often legislatures are meant or designed to be that avenue. Is part of the reason that people are leaning on the courts because of legislative gridlock, or does it perhaps go the other way?
There's always legislative gridlock. That goes back from the very beginning of the Congress. There's also always legislation. When people complain about legislative gridlock, they're saying, I didn't get my bill through. But just notice, you couldn't have a more contentious time in American politics between the Republicans and Democrats, and you just saw a bill pass through the Congress, which Republicans think is terrible, but some Republicans supported.
The court of late, Supreme Court, has taken a more expansive view of using public money for private schools. I think there was a Maine case to that effect.
Yes, it was.
Can you talk about that case and then what you think the larger implications might be for religion and for schooling?
I think the case stands for the proposition that if the government is going to demand certain educational attainment and spend money for schools in rural areas and require them to have an activity, they can't exclude a religious school. Pretty limited. If Congress were to directly pass legislation funding religious schools, it becomes more difficult. But the movement has been more and more in the court to accept the proposition that if you fund parents, you're not creating an establishment clause.
This one just came in. Why are opponents of the Dobbs decision insistent on removing contentious subjects, obviously abortion, from the democratic, small d democratic process? In general, why are people on the left at the moment ready to cede their political power to an unelected council of lawyers, presumably the Supreme Court?
This doesn't sound like a hostile question.
I'm just reading.
I thought I've already.
We can go back to January 6th if you want.
I thought I've already answered that question.
Okay. This one's from my daughter, who went to Chicago Public School and was always irked that she had to stand for the Pledge of Allegiance. And so I told her that if she wanted to sue in federal court, I'd support her. She never did. So what would have happened? My understanding is are there conflicting circuit court decisions on that? Has the Supreme? And so walk me through that so I can call her now that she's out of college and tell her she may have missed the bus.
If the case came to the Supreme Court, my prediction is the court would conclude it was not illegal to ask students to stand for the
Even with
pledge
the
of-
under God provision.
Oh, no, then that's a separate matter. I think no student is required to say under God.
All right, so you have to stand for the pledge, but you can say what you want.
Well, you can't say it. You can avoid saying
You
under
can avoid
God.
saying what you want. All right, well, she's not going to be satisfied by that. These are the questions that have been asked. What haven't we asked about? What are, to your mind, cases that might be percolating in the lower courts that might be what we're talking about 2 or 3 years from now?
Ye gods. I can't imagine. There'll be more religion cases because the free exercise clause is expanding a little. So there'll be more of that. But they're not all, I don't see that they're all terribly significant. There will be, if the Supreme Court overrules the Harvard case from the First Circuit, there will be years of litigation because universities and colleges will not take it kindly. So it'll be like Brown v. Board over again, taking years of litigation. There's a big case in the Supreme Court from North Carolina that deals with the question somewhat similar to the question of whether or not legislatures have the sole right to set time, place, and manner of elections, or can governors and Supreme Court justices of states decide those questions. There's a big case coming up on that. Looking 3 or 4 years in advance, hell, I can't even think of 6 months in advance.
My understanding is that as a circuit court judge, the Supreme Court decisions are your instruction manual, so I'm a right. All right, well, first of all, you can address that.
Ooh.
But the question is, who among present Supreme Court justices are the best writers, both because of their incisive legal logic, but also their use of the language?
The best writers, in my view, are Sam Alito and Elena Kagan.
And what is it that makes their writing stand above the others?
Their style, they have quite distinctive style and a certain elegance in their putting together words.
And does it make them more persuasive or just more entertaining?
You know, the truth of the matter is, very seldom do Supreme Court justices persuade each other. I remember when my dear friend Nino Scalia went up to the Supreme Court. He called me 6 months later and he said, Larry, no one talks. No one discusses these cases. They just come in and vote. It's more that than, it's funny that sitting on the Court of Appeals with only 3 judges, we find it much more, and those who went to the Supreme Court from our court say the same thing, much more discussion amongst 3 judges than there is on the Supreme Court.
So since we're almost out of time and you're here for your 65th, I'm going to give you a nostalgic question. What, while you were a student here, helped shape your worldview as you made your way through your career?
I took a professor by the name of John Adams for history. He taught modern European history. And John Adams once told the class that the Serbs, who of course started World War I, were the greatest people in Europe because they could reduce the most complicated questions of politics, economics, whatever, into a simple formula. 9 grams in the back of the neck. That led me inexorably to be ambassador to Yugoslavia.
Good. Well, thank you very much for your career, for coming back and sharing your thoughts with us.